Welcome everybody, and we're super excited about what we have planned for you all today. Today we'll be talking about intellectual property and transfer pricing, and we're very lucky because we've got a fantastic panel of experts with us today. The main focus will be on South Africa's landmark court case around IP and TP. It's been a long time. We've been waiting for some type of precedence on TP and really any type of precedence at all when it comes to intellectual property. So we're super excited. Quickly, I'll introduce what we'll be covering. We will go through the case. What are the main facts? What are the main TP technical matters? What, in our view, are the key findings and takeaways? Then Rachel, who we'll introduce to you just now, will talk about the key legal considerations of IP, and Theo, key considerations of valuation. And we have Keith, our esteemed Keith Engel from site here, who will moderate and run this workshop with us. Keith, we're so happy to have you on board. Welcome.
Thank you. It's always good to be with you guys. I'm very impressed. That's my short answer.
If we're impressing Keith, we're doing well. And let me introduce our other speakers. We have Rachel Sikwani, Managing Director of RNMS Incorporated. Rachel is a commercial lawyer specializing in intellectual property and has a big passion for cross-border IP transaction strategy and structuring, and works with her clients essentially on all legal aspects of IP and intellectual property. Rachel, do you want to add a bit to that introduction?
No, I don't want to add anything.
A few compliments for yourself. We'll do the compliments. So, okay. Then we also have Theo Duval, who's a director at Bowers Incorporated. He's got many years of experience practicing patent attorney and director of the IP law firm Bowers Incorporated. He will focus quite a bit on the valuation side, and Rachel on this key topic of identifying, what is an intangible, what is IP, because it is a little bit this unknown concept floating out in the world. Theo, have we got you there? Not just yet. Okay. So let's start. And Keith, I'm going to start before we get into the facts. I'm just going to start with you. Just in terms of your one-liner, what do you think of this ABD case? What's your gut instinct on it before we get into the facts?
Look, I thought it was an interesting case. My biggest question was why SARS chose this one. Yeah. Because the bottom line is that it's an outbound case, and you're sitting there. It's not like there was big abuse going on from a global tax perspective. What you saw there was they were interested in just getting more revenue, even if the taxpayer wasn't obviously playing games. And so the real question was, why take this one? So that's, I think, a main point.
Well, we will get into that a bit later on, and maybe there's wider reasons around that. But yeah, I think it is a good question, because we obviously know SARS resources are pretty scarce. We want to focus these tax resources in the right place. We want to make in the right precedent. And how does this tie in with kind of SARS wider strategy? We can make some maybe educated or half-educated guesses on that later on. But let's get into the facts. So ABD is a South African telecommunications company with subsidiaries essentially across the world. And ABD licensed intellectual property, we're going to call it brand for now, to these various operating companies for the right to use of the brand. And what this IP was, Rachel will go into a bit more, because there's a lot of debate around, is it brand, is it trademark, is it goodwill? And there's a lot of debate around what the IP is. So that's a kind of a starting point. Essentially, ABD was charging a royalty of 1%, and the tax authorities were not happy with this and were looking for higher levels of royalties. And then there was a whole lot of work by various different experts to basically support both sides of the argument. The expert witnesses and the expert opinions looked at various different methodology, and essentially it boiled down to two types of methodologies that was looked by on all parties. That's the transactional profit split method and the cup method. And one of the biggest debates was around, what are we dividing up? The core issue is, what is the actual transaction? What is the actual IP that we're licensing? And what profits relate to this, or what revenue relates to this? So what is the pie that we have to look at dividing up? And what percentages of this pie is the right percentage to comply with arm's length principles? So that's the crux of it. So the first thing that everybody agreed on, and we love when everyone agrees on anything in a case, is that the OECD guidelines are the correct principles to be following. And when it comes to anything on transfer pricing, the arm's length principle is the right principle. So there was no argy-bargy about that, but even the judge in the case is talking about, even based on the OECD guidelines, there's so much kind of subjective or judgmental information in there. Even with these guidance, there's such a level of interpretation that the expert evidence and opinion is absolutely critical, right? You have to use qualitative and quantitative information to support anything, and light level approaches in terms of TP is not going to work. The next thing we talked about is, what's the pie, right? So what's the size of the profit earned by the opcos from the use of the IP? The first thing is, if you're going to pay for the use of IP, you have to have an economic benefit. So we have to look at what is the mechanism for deciding what this economic benefit is? Is it a profit pool? Is it a revenue pool? What's the pool, the whole pool? And then, of course, we look at the division of this profit between the opcos and, of course, ABD as the economic and legal owner of the IP. So the pie and the division of the pie, everybody agreed on the concepts. Of course, they didn't agree on the slice of the pie that was attributed to the various tax jurisdictions. In terms of the actual transaction, SARS assumed that the brand rights included goodwill, and ABD disputed this. And, it makes a big difference. Again, is it brand which attributes this value? Is it brand and additional points which has a higher value? So again, what the IP is has been quite critical to this case. The judge determined, however, that this was just trademark and that goodwill was not incorporated into that. And I know Theo and Rachel will delve into that a bit more. How do you separate goodwill? What's local goodwill? What's group goodwill? How do you separate that from a trademark? Is it appropriate or not? And what are the facts that support it? In terms of transfer pricing methods, and I think this was a critical part of the whole case, is every transfer pricing method actually comes up with a different result. If you're going to use a cup method or a profit split method or a T&M method, whatever method is determined to be right, you're going to come up with a different financial result. So that's why there's always such a debate about what's the appropriate method. In this case, the focus was on the profit split method and the cup method. And both methods were considered viable, but ultimately the decision was made around the cup. I think it's also important to note that on both sides, ABD had what's called a dual or collaborative approach. So they relied on more than one method. And there is global case law on this. If you have collaborative support and it helps support your position, this is very, very useful. So I think it's a good point for the tax authorities. If you have a primary method supported by another method, that's helpful. But at the end of the day, the cup method was where the courts applied their decision. And we didn't get that much technical learning, say, around the profit split method, which I think a lot of people would have enjoyed. So it all boiled down to what we call the Cyprus Cup. So basically, the cup is considered one of the most direct and reliable methods to support the arm's length principle. And in this case, ABD relied on the information of a former subsidiary in Cyprus. There was a sale, and there was no brand license agreement in place. But post-sale, when they were independent parties, Cyprus Co. did enter into a brand licensing agreement and did agree with this 1% royalty, which was similar to what was being agreed with the third parties. So this internal cup was considered the most reliable of all the data, and there was much, by various experts put in front of the courts, and it was upon this that the decision was made. There was a lot of argument, typically with a cup, an internal cup like this. There are adjustments made to ensure comparability, and SARS made a lot of arguments that there should be adjustments made to this cup to make it comparable, and didn't find it comparable on a standalone basis. However, the judge decided in ABD's favour, and no adjustments were considered relevant to the cup. So the summary of the judgment is, first of all, this was a win for the taxpayer. The 1% stood stellar. Will there be appeals? Will there be more to come in this regard? We can expect so. But what was super important is that the judge had determined that there was no factual basis for the commissioner to have adjusted the royalty. With all the different facts and analysis that was there, the judge said there's no factual basis. This internal cup is solid. And on a further point, that there's no incentive for ABD to undercharge its subsidiaries, as tax rates in the other jurisdictions were no more attractive than SA. Sounds like a small point, but Keith, it's exactly what you're saying earlier. It's gigantic. They're saying we don't have an incentive to manipulate taxes. Why would we do this? Why would we not accrue more revenue if we could? Why would we not? We don't have an incentive to manipulate tax in these jurisdictions. Why would we do this? You know, looking for some sense apart from the commercial nature of the transactions. I'm going to do the key takeaways, Keith, and then I'm going to ask you for your input. Key takeaways are the OECD guidelines are absolutely critical. Every court case now is referring back to them, South Africa, Africa, all of them. We got to stick with the OECD guidelines. Tax administrators should not automatically assume that enterprises have sought to manipulate profits. This is key. Judges take an incentive to shift profits into account. So this is important, not so much in this case, but in other cases. Are we dealing with low tax jurisdiction? That's a potential incentive involved there. And the judge is almost saying to SARS, maybe you should focus more in that direction, because we don't see the incentive here. So why are we focusing here? I think that's in line with your point, Keith. The next point is identification of IP, what this IP is. This is really not a simple exercise. When we sell a good, we can say this is a sale of a good. But when we look at IP, is it brand mark? Is it trade name? Is it copyright? Is it legally protected? What's the soft parts? Is there know-how? Is there operational process? Every business arguably has some level of intellectual property or intangible that has value. As part of the new documentation requirements with the master file and the local file, the taxpayer actually has to describe their IP strategy, right? And one of the big problems is that we haven't focused enough energies on actually identifying the IP and making calls on it. Is it valuable? Do other jurisdictions benefit it? Should we pay for it? Should we not pay for it? What it is? Expert and economic expertise is absolutely critical in the defense of any transfer pricing policy, and the complexity of this cannot be ignored. We'll often see in our local files we have a benchmark, and everyone thinks this is the part they don't read. Ultimately, in a dispute, your economic analysis is king or queen, as the case may be. It's absolutely critical to your defense. Your fact pattern, of course, is critical, but that's basic. Your economic, your benchmark, whether it's external, internal, whatever method, you've got to be there if you want to be able to defend your policy. Cups, and particularly internal cups, simply cannot be ignored. Okay, simply cannot be ignored. There is often a case where we transact with third parties. And if we want to argue that it is not similar to how we transact with related parties, we best do the work and write the narrative in our local files to support that fact pattern. It is very often ignored and say, oh, it's not the same. Why is it not the same? In this case, SARS didn't even make any adjustments, right, to the cup that was there. So whether we want to use it or we don't want to use it, you cannot ignore internal cup data, and it's got to be analysed and scrutinised and incorporated into your work. We can expect more TP cases, and one of the things we've debated here is, Keith will say, why this? And we'll say, what will SARS do now, right? As a percentage, when we look at IP, is South Africa not paying a larger portion of outbound in royalties? Is South Africa not paying a lot of global multinationals these royalties? And that 1% might look very, very low, right? So if SARS is only getting 1%, then why is everyone else paying if the case might be more than that? So we expect to start look at the other side of the equation and to start build up the numbers on that. SARS will have seen countless of TP documentations which support the outbound payment of a royalty, and one can bet your bottom dollar that they're not always 1%. Now, of course, different brands, different whatever, but you can imagine that SARS brain might be ticking in that direction. So whether it's an inbound royalty, a non-payment of a royalty, or an outbound royalty, this is SARS' first step into the foray of IP, and we can expect more to come. Keith, before I let Rachel jump into her section, give us your feedback, give us your thoughts, let us know what you're thinking and what you've heard on the ground from people there in South Africa.
Yeah, so look, I think, of course, the industry is quite happy, to know that, in the battle that they can win a transfer pricing case. I think the big scare always in transfer pricing cases, will the judge look at it thoroughly? Now, you can agree or disagree with what the judge did, but it was a very well-written case. I was very impressed with this judge. So maybe, you could disagree on certain arguments and whatever, but he obviously really made a serious attempt at dealing with this. And I must say, when I read the thing, it's very well written. It's a very clean English opinion. Normally, these opinions get very, you're not sure what they're doing. So I was very impressed with the writing skill anyway. Turning to the issue, I mean, some people say, just like you said, that, well, SARS, if they lost this, that they won it. Because now, if people are overclaiming on the other side when money is going out, this helps them. I don't think the SARS people, though, thought about that in that way. I'm not saying that the SARS people are not clever, but oftentimes they back into things. And it seems to me, just based on experience, they looked at this more like the way they look at services, and they said, gee, 1% has got to be too low. And they just fought that number from the very beginning. Something tells me they didn't know about the internal cup until later on, because had there been an internal cup, that would have been later. And so I think the other issue that's disturbing there is that, the bottom line is there's no global tax abuse. Now, this is an old chestnut of mine. Transfer pricing should be a last stop, not a first stop. And so when we see a lot of these battles with OECD, and it's been going on for 10 years, the original battles on action points and all of this was about, the global tax gap, tax justice network. But it's quickly evolved into what's mine versus what's yours. And so what you're seeing with the revenue service is, well, we don't care what's going on, whether you're up to any avoidance. We think, we deserve more. And that's a bigger problem, as you know, in Africa overall. So that it's about we deserve more. And then what you're seeing is increased option for double taxation. So the point of the matter is, yes, transfer pricing does not have to have an abusive purpose. You can apply it strictly, but it's nice to know that it's a factor in the consideration, that the taxpayer was not evil. So I was happy with that. The other ones, we'll get to the goodwill issues, because I think that's something. The internal cup, now I guess they said, look, it was owned all along and then you sold it, and therefore it's not a great internal cup. But I'm not sure that why they were not able to disprove why it's an internal cup is bad, because the bottom line is, going forward, the 1% is the 1%. Now they should have focused and said, well, maybe it's only 1% because of the price. I don't know what, but I don't remember anything on the OECD guidelines saying that internal cup is bad because the thing was formally owned. It's, so I don't see that. And what was the other one I wanted to raise? The other one that I think is worth discussing is a bit of an evidentiary issue. There was issues. Transfer pricing isn't just about, it's often getting that third-party data. And one of the things that interested me from a legal point of view was this thought about certain surveys cannot be relied on as hearsay. And
Yes.
we've never talked about that before. So, we all talk about, we get our information from wherever we get it from, and it'll be good. Now, again, if it's contemporaneous, it's better. But clearly in court cases, you're going to be building up evidence. And so what gets knocked out at hearsay and transfer pricing is actually very important. And they touched on it. And that, because when you're preparing these things, you need to keep that hearsay in mind. Not something we talk about. We just kind of assume everything's in if we can get it. So those are some quick general thoughts, maybe too much. So let me just stop and let you jump in.
Perfect. Thanks, Keith. Look, great points, and they're exactly, some of the things that we need to be debating about. Why this case? What does it mean? And what will all this precedent mean going forward? So thanks for that. Very insightful. Rachel, I'm going to hand it over to you. You will be covering the key legal considerations of IP. So over to you, Rachel.
Thanks, Cabrini. I do want to actually maybe just touch on that first point that Keith made, and he made it a few times, just around, why this case. There wasn't any abuse by ABD. So why did SARS choose this case? And actually, while doing a bit of research for this presentation, I came across the Veritas case in the US, where similar sort of point was made by that court against the IRS, that transfer pricing is not about trying to increase revenue. It's meant to, where there's a clear abuse, or where there's where there's a clear abuse or concern of clear abuse, that's when you want to impose your transfer pricing powers and conduct assessments on that basis, not to just pay 1%, let's see if we can get it up to 2 type of situation. So just adding to that point that Keith's made a couple of times. Okay, so key legal considerations of IP. So for me, this graph that's now displayed, I think, is always just a good starting point when talking about IP, because it's a reminder of the importance of IP in our world today. So you'll see on the graph, less than 50 years ago, intangible assets accounted for 17% of the value of the S&P 500's total assets. But then in 2020, intangible assets accounted for 90% of the value of the S&P 500's total assets. And
this is startling, Rachel. It's startling.
It really is.
It really startling. Is. The sign of the times. So we're focusing on stuff, and look at that. That's unbelievable. Yeah.
Yep. And I think even for those that are listening, this is a graph referring to S&P 500 companies, but even in your own company today, it's highly likely that your intangible assets, are potentially your company's most valuable assets. And if you're not convinced, if you just think about, how your company adapted in 2020 when we were going through the pandemic, a lot of office buildings were abandoned, and people were working from home because it's what's in here, or how you apply your knowledge, that actually carries the value and adds value to your company and to its business. So intangible assets and IP, they're valuable, and IP matters because of its value, but it also matters because of its impact in a company. So I'm not sure who's running the slides, but if you can move to the next one.
It's me.
So you may not always consider this, but IP actually impacts most areas in which a company engages. So, for example, when a company engages with its employees or consultants, you'll want to make sure that your employment contracts provide for the ownership and use of IP. When a company acquires or disposes of assets or business units, if it concludes, a manufacturing contract or a licensing contract, there are IP implications that would come up there. IP is also relevant when you're considering restructuring, insolvency issues, and also when engaging in joint ventures. Who owns the IP between the two parties. And in fact, it's then also relevant or has an impact when you're looking at a company's incorporation documents. So in shareholders agreements, if one shareholder brings in the IP that's relevant to the business, how is that dealt with? But yeah, while preparing for this presentation, I actually realized that my graphic had to be updated because IP is clearly also very relevant when a company engages in transfer pricing. And so that's then the additional comments that I've had there. So why IP is important, why it matters, because of its value, and also because of the numerous aspects within a business that it impacts. Okay, so what is IP? And basically, intellectual property falls within, I guess, what one would call a body of assets known as intangible assets. And intangible assets, we've basically said they're corporate resources that don't have any physical presence or physical existence. And they also don't include financial assets, to be clear. And they would include things such as, reputation, name recognition, human capital, culture, know-how, trade secrets, information databases. I've provided a whole list there, but software platforms, trademarks, patents, and then also unpatented research would form part of the pool of intangible assets. Customer lists, the list goes on, literally goes on. And we saw it in this case, but it is often that, intellectual property and intangible assets, they're often, used interchangeably. And that's not, always correct. Intellectual property is then a subcategory of intangible assets. And that would include rights of ownership that are established through registration. So you have patents, you have trademarks, utility models, registered designs, and then also plant breeders' rights. These rights basically come into existence through registration. That would be one form of intellectual property. A second form of intellectual property would be the rights that come into existence or are established by legislation. And a good example there is copyright. And then you have rights of possession and rights that are established, I guess, through possession. And there you would have your know-how, your trade secrets, and your confidential information. So that, broadly speaking, would be intellectual property rights, and sort of the subcategories. No, previous slide, please. The three subcategories that are covered by the term. So, in referencing intellectual property within the context of transfer pricing, it is important to be specific about the exact nature of the intellectual property rights. The reason being is because each of the different rights, or rather each of the different properties, have different rights that attach to them. And then also identification of IP, it's a separate and distinct process from determining the price for the use of that IP or the price for the use of that right. So you first have to determine what the right is that you're dealing with and the extent of that right before you can look at, what the appropriate price is for the use of that right and whether that price was determined correctly. And I mean, you mentioned this earlier, Cabrini, but that's basically what was, discussed in this case and in this judgment. There, in the introduction of the judgment already, the court held that, ABD had charged all of its opcos the same royalty of 1% for the use of this IP, but it is the extent of what that right represented that was in dispute. So next slide then. What are the IP rights and what are the intangible rights or intangible assets that were considered in the case? There were three main ones: brand, goodwill, and trademarks. And what I have done here is I've just noted the paragraphs in the judgment where definitions of these terms are provided. But I think that the definitions, and I'll go through them now, but the definitions are actually best discussed, I think, with reference to the Venn diagram that I've included on the slide. So we've already looked at the definition of intangible or intangible assets covered by the blue section. That's the all-encompassing term. The term brand, though, that's sometimes used interchangeably with terms such as trademarks and trade names. And that's not strictly correct from a legal point of view. A brand typically refers to a combination of intangible assets. So it will include trademarks, trade names, customer relationships, reputational characteristics, and goodwill. And it may sometimes be difficult or even impossible, actually, to transfer separately the various intangibles that would contribute to one's brand value. Then, depending on the context, the term goodwill can have a number of different meanings or concepts. I know that like in accounting and some valuation or business valuation contexts, your goodwill would refer to the difference between sort of the total value or aggregate value of the business and the sum of the values of all the tangibles and intangibles, and the difference between those two amounts would then be the goodwill. Another definition is, goodwill could be used to describe the future economic benefits that are associated with a business's assets, and then, or at least those that are not individually identified and seen separately or recognized separately. And then it can also be used to refer to sort of future expectation that one has of future trade from existing customers. So, one's ability to just attract custom and attract future trade. I think an important point, though, to note is that it's generally recognized that goodwill can't be transferred separately from other business assets. And then the smallest circle there would then be a trademark. And a trademark is a distinctive name or a symbol or a logo that the owner of that trademark uses to distinguish their products and services from those of other entities. And one would acquire proprietary rights in a trademark through a registration system. And once the trademark is registered, the trademark owner is then able to exclude others from offering the same or similar services under that same trademark. So distinguishing this then from goodwill is that once it's registered, a trademark can actually be transferred separately from other business assets. And it can be transferred with goodwill or with the goodwill that attaches to the trademark. And I think this is where the question that triggered sort of the discussion around pies in the judgment. This is where it emanated from, because, you know, as you mentioned earlier, Cabrini, that ABD argued that the pie that SARS had considered covered the orange and the red. So it covered goodwill and trademarks. And ABD said that it should have actually just covered the orange, the trademark, because it is only the trademark that had been licensed to the opcos and not the goodwill attaching to those trademarks. So just I think a concluding remark is obviously it's important, you know, to be specific. I think we learned from this case, it's important to be specific when identifying and defining IP. Words that, you know, may seem the same: brand, trademark, trade name, goodwill, even reputation. They may seem the same, but they have different meanings, and failing to properly identify and define them can potentially lead to disastrous outcomes. I think also the fact that the OECD guidelines make it clear that where a cup is available, it is the preferred method to use, particularly where the cup is an internal cup. And, you know, the comment that you made about the fact that internal cups cannot be ignored. And I was trying to, you know, sort of pull all this together into some sort of practical application and question for consideration. Is that, you know, where you have, for example, a company in South Africa that licenses its brand to a company in, you know, Malawi, and a royalty is then paid for this trademark. Let's say they're assuming they're only licensing the trademark. But then, you know, infringement action is taken in Malawi, and the infringement action is based on not just trademark rights, but also copyright. And so there, the question is, okay, well, if SARS were to, you know, issue an assessment and argue that, well, you know, this licensee has been paying X% for the trademark, but it's clear from these papers that actually they've licensed the trademark and the copyright, and it's on that basis that, you know, they've instituted proceedings. That sort of, you know, it's not an internal cup in that, you know, you have a formal license agreement, but that is information that would inform an internal cup, and I think would be material to determining whether or not an assessment is warranted for an increased royalty to cover not just a trademark license, but also copyright. So I think there again, it's important how you define, you know, what you're licensing, how you define what is being paid for, what the IP is. Yeah, that's me.
Yeah, Rachel, I think it's fascinating that we have gotten this far in a conversation around intangibles and intellectual property without talking about the DEMFI. So the legal ownership, the economic ownership, who's responsible for these functions. Normally, that's the starting point in the IP case. And in this case, it wasn't debated. But when it comes to IP, that's typically the fundamental point. Is in this case, they've agreed that South Africa was the legal and economic owner. And often the cases, like you talked about with the example in Malawi, who's doing the DEMFI function is the legal and economic owner. But if Malawi is responsible for protecting the copyright, is responsible for maintaining it and building the brand locally, then you're talking about a whole different kettle of fish and a whole different pot to be shared. So yeah, really interesting points. I think it's fascinating to see the value of intangible assets sitting within all of the businesses, and how it is now unavoidable to actually take the steps to properly define what IP is in your business, what is intangible, who uses it, because trying to price stuff later on is impossible without actually, you know, really defining and deciding on what IP is and understanding that in your business, determining whether or not it is a key value driver within your business. And then you get to the more complicated questions of, you know, where does this IP sit? Is it dispersed locally? Is it centrally? Is it in this location? Yeah, and after all that hard work is done, we can start to say, okay, this is what an arm's length charge for that IP may or may not be. But thank you, Rachel, for that. Super interesting. Theo, we introduced you earlier, but I didn't get to see your face. I believe you're here now. Lovely to have you, Theo.
Good morning, and I apologize. Yes, as usual, when it comes to IT, I know little, and but I'm here. Thank you very much.
Super. Let me jump into your slides. Fire ahead, Theo.
I want to pick up where you and Rachel just kind of ended up with, and it was the comment from Rachel very importantly about the specificity about the asset under discussion, be it intellectual property or intangibles, and secondly, the observation that you made right towards the end about that DEMPI never came up in the conversation. I think it was under the surface all the time. I think it was never perhaps analyzed formally, but there's some interesting questions around that. So what I would, having had the benefit of Rachel's conversation and analysis, I can focus more on the valuation side of things. And I first just want to deal with the apparent confusion that one often gets around the references to intangible assets versus intellectual property, and particularly when it is a so-called valuation or an accounting and reporting exercise, or whether it's a transfer pricing exercise. And classically, intellectual property is valued from an intellectual property perspective, be it from a litigation or damages perspective. There's some IP laws that make specific provisions for the determination of reasonable royalties, for example, or whether it's an accounting. And I find it important to appreciate that these come from different legal frameworks. You have to wear different glasses when you look at these things. If you do a conventional or classical IP valuation, then you look at it from the IP statutes and common law. You look at the case law textbooks and articles, etc., and the numerous guidelines and standards around IP valuation. When you come with your accounting hat on, the previous one being your IP lawyer typically, when you come with your accounting hat on, you look at it from an intangible asset perspective. You look at it from an AIS 38 perspective. That's your Bible. And whatever intellectual property or you want to work with, it has to meet those requirements. And perhaps one can then stand back and say, where do these definitions come from? Funny enough, intellectual property as a term appeared relatively lately in the case law and textbooks in South Africa, and it was only formally recognized in the Intellectual Property Rights from Publicly Research and Development Act around 2008. Before that, now and then judgments would make reference to it, case law would make reference to it, articles here and there, and international authors. But intellectual property per se was never really properly defined anywhere, at least formally. Immaterial property is in terms of the South African common law. It is well defined in terms of the law of subjective rights. And you look at textbooks like Neertling and Van Heerden, etc., that goes to long detail about that. When you speak, therefore, about these different things, one always have to appreciate the different legal frameworks and, more importantly, the requirements for those. Can you change the slide for me, please? Thank you. We know those. I'm not going to deal with it. I thought it interesting just to point out that they deal with cost or market or profit splits. And that is an important principle when you look at it from a transfer pricing perspective, and you can go immediately to the next slide. And if you look from an intellectual property valuation perspective, you will see that although we give them different terms, we still focus on the three elements, be it a cost-based approach or a market-based approach or an income-based approach, obviously a few hybrids. But the cost is exactly where you come from a transfer pricing perspective. The market is your market comparables, or the income-based, your profit split or your profit margin. So even from an classical IP valuation perspective, you also look at those through potential different perspectives. Now, I think Keith mentioned earlier that every time you use a method, be an IP valuation method or a transfer pricing method, the different methods come to a different answer. And as an IP valuator, I can say to you categorically that is the case, but that is before adjustments. So from whichever perspective you're coming, you have to remember that you're looking at a particular asset, particular rights relating to those assets, the various subjects, the authors or the proprietors or licensees, whatever the parties involved, and excuse me, and therefore, whatever methodology you use with whatever goal in mind, goal being transfer pricing or accounting and reporting or IP valuation, whatever method, whether it's cost or market or income based, you have to at the end, from a valuator's perspective, then say, what adjustments must I make? And typically you then find from whatever method approach you're coming, you're starting to approach what we call a certain target. They start approximating each other. And perhaps as an outsider, that's perhaps my biggest critique against the present case, is that once the court focused on the cup, and especially the internal cup, it's as if we all fell in love with that particular approach, and out of the door went all the criticism. The experts by the taxpayer made the differences down to immaterial, perhaps, often indicating clearly that it wasn't even valued before one can determine whether those were immaterial. And therefore, from a valuator's perspective, I think the process ended kind of halfway, perhaps. I would have loved to see them going forward with a profit split approach, and to perhaps look and see to what extent these would have approximated each other. And those are necessitated by an appreciation that no method is perfect. Certain methods come through strengths and weaknesses, and it's clear that the COE guidelines from 2020 to believe strongly in CUP. I want to put a question mark a little bit about that. If one reads it right through with regard to intangible assets, it's not such a strong indication. They seem to back off a bit on CUP. So it comes back to, again, my earlier comment, whatever approach and methodology you're going to follow, you have to question before you fall in love with it, what adjustments ought to be necessary based on circumstance, based on DEMPI, based on the normal comparabilities tests, so as to see where you're going to end up with. And I think then that 1% might have been slightly tweaked, if I may be so naughty. Please go to the next slide. Thank you. Just a comment before we move on. Those are typically the goals that you have in mind when you do an IP valuation, and under tax, obviously, a tax transfer pricing could be the point. Next slide, please. Just quickly, what I've said already. Therefore, from an IP valuation classical perspective, you're looking for a fair market value for that particular asset and rights relating to that asset, sometimes ownership, sometimes else. From an accounting perspective, typically you're looking for the actual costs. Accountants, they love costs. It's all about costs in their financial reporting and the fair value of those assets. And then obviously from a transfer pricing perspective, what are the at arm's length profits and what is the profit splits, the proper profit splits between the parties. But largely from the same perspective we're coming towards. The next slide, please. Therefore, yes, there are dissimilarities whether you classically IP valuing, whether you doing a financial recording and reporting, or whether you are doing a transfer pricing exercise. But similarities are there. We are assessing the same asset, be it an intangible or an intellectual property. We're looking at the same parties. We're looking at the same rights. We're looking at the same transactions. We use a cost or a market or an income approach. We do the comparisons for the best fits, and we look for the adjustments needs necessary, whichever one you follow. Internationally, from an IP valuation damages perspective, there's some very interesting case law. My next critique, perhaps, against it, there was reference to a very interesting case regarding experts. I would have liked to see the reference to Georgia-Pacific and Unilock, two of the Bible, the classical judgments internationally in IP valuation damage determinations. You can go to the next slide, please. Under the Georgia-Pacific case, the American federal court identified 15 specific factors that you ought to consider when you consider a reasonable royalty. And very specifically, length of license term, exclusivity, territory, 3 elements that were dismissed by the experts and hence by the court in the particular case, comparable. Those are cardinal elements, and I therefore, as my critique, felt that the expert played them down without really having gone there. And if counsel referred to the Georgia-Pacific case, I don't think it would have been that easily swept aside. Those are the 15 factors for whoever wants to read, and I gave the reference to it. The next slide, please. In Unilock, Keith, came the issue about hearsay. The Unilock case actually dismissed a very old rule used in IP valuations, the so-called 25% rule, which is basically a profit split rule. It classically say that 25% of the operating profits attributed to the particular intellectual property under discussion ought to go to the licensor in a kind of a assessment. It's based on years and years of analysis, data, bases, etc. And the court felt that it was an arbitrary connection to the case at hand, the hearsay, i.e., and actually dismissed that. And again, I thought my third critique, where the expert on behalf of the taxpayer kind of started and stopped at his analysis of the royalty rates to justify the 1% and that there was no adjustment necessary. Unilock is explicit about it. It says you ought to start with a case and then do adjustments if necessary and justifiable by old records. You have to appreciate that all those databases do not necessarily identify the differences in the different license arrangements. So whether it was a 1 year or a 10 year, whether it was only for the trademark or a brand or for the whole host portfolio of intellectual property of relevance at a particular product or service, whether it was for a country, whether it was protected, etc., whether it was registered IP, a lot of that does not come up when you analyze and look at databases reflecting royalty rates. And therefore, the court was extremely critical of that approach. Perhaps a bit of a conflict, perhaps a bit of a interface between transfer pricing and IP valuations, in this particular case, damage determinations. But I think it's an element that a court like this ought to have looked at. I share Keith's opinion about the judgment. I think it's a good, well-written judgment. The courts are led by the counsel, by experts. And over time, I think these gaps will be filled up. If we can go to the next slide. It therefore leads, thank you, here it is. Therefore leads to certain questions remaining in one's head. Mm-hmm. Would the difference in territories, financial performances, market share, brand, etc., would that have perhaps at the end led to a bit of an adjustment of royalty rates? I think so. Goodwill, my favorite topic. Rachel, you mentioned all the right things. Thank you very much. one has to differentiate with the fact that the goodwill in the broad sense, as well defined in AIS 38, those intangibles that do not, or those intellectual properties or intangibles in the broad sense that don't meet the requirements for intangible assets in terms of AIS 38, all thrown into the bigger basket of goodwill. But as Rachel clearly indicated, you can assign a trademark with goodwill. You can license a trademark and then determine where the goodwill relating to the trademark, not the business, where that falls. I believe that got lost in the wash. I believe that I would have liked to see a more scalpel approach to the goodwill in those particular license agreements, because here I find my next critique. I would have wanted the court to say, because we have to bear in mind that the Cyprus transaction was less than 7 weeks after that company was sold off. And a bit of an afterthought, I would think. And my feel is it is not such an at-arm's length third-party transaction as people made it out to be. I think it was a recent sale off, and the lawyers forget to deal with the trademarks. If one further looks at it, you must remember that it was only for 3 years, and that thereafter it was an independent third party that might reconsider the use of a trademark that belongs to an independent third party. Where in the OpCo transactions, that brand is part of the group, and the goodwill in the business that gets enhanced by the use of those trademarks are going to survive even a termination. So in my head as evaluator, there is a material difference in licensing trademarks to an arm's length third party who may have to abandon the use and therefore lose a lot of goodwill that developed around the use of those trademarks, versus group opcos that have 10 years and in some cases indeterminate lengths of periods of time of use of that. There's a massive difference in that. And in my opinion, the royalty rate should have been adjusted. You can go to the next slide. There were my questions. Based on the above, were the trademarks licenses really comparable? And if so, if you fell in love with the cup method, should you perhaps have adjusted it? I think so.
It does seem strange, Theo, no adjustments to the cup for these kind of fundamental points like territory, like duration, no amount. Yeah, it was almost like nobody did the math around putting forth what those potential adjustments might do, because an adjustment can have a very material impact. Yeah,
absolutely,
Cabrini. I did notice though that one of the comments that were made was that if an adjustment were to be made, for example, for considering the term of the license, that it would actually be lower than the 1%, and that I mean, I can't remember exactly what the reasoning was, but I do remember reading that if anything, for the 10-year term, that the ultimate royalty may actually be lower than the 1%, and so the court sort of justified the fact that, you know, the advice that had been given to ABD was, here's a range, so we're giving you a range, and, you know, in this range, let's rather stick to 1%. It's sort of a fair amount that takes into consideration any adjustments that would be made on either side. I think that's sort of what they were looking at there.
In line with that point, Rachel, the other one was the opcos got exclusive versus non-exclusive, and one would have thought similarly exclusive is more valuable than non-exclusive. So there was probably adjustments either way that could have, maybe the judge is saying they balanced out. Who knows until you put numbers to it, which are also arbitrary, and probably if they made too many adjustments to this cup, they'd be back to throwing the cup out as not comparable enough and back to the residual profit split, and the judge didn't seem a big fan of that anyway. So yeah, that's where we landed.
Absolutely. And Rachel, those comments were made in paragraphs 62 and 63 of the judgment.
Yeah.
And the judge kind of made it down in a way where he said these are legal rather than economic analyses. I'm not sure that I followed those argument, but I stand where you stand, Cabrini, on that point, is that do the math, work them out, and then see, did they really at the end settled in the same place? And if they did, well done. I agree. I think the expert in that case, Rachel, shot a bit from the hip. My feel was she made arguments that a longer license would not necessarily change, or she and a co-expert made arguments that a longer license or some of those differences might impact on the value rather than the royalty. As a valuator, I failed to see the distinction because we typically determine values by means of a royalty. I therefore see them as connected variables and therefore not as independent variables. But enough said. A very interesting case, some interesting points, and perhaps we would have been less critical of the judgment if we also had the benefit of all the expert documents. So maybe we would have come to the same conclusion. And at the end, yes, a judgment can maybe 500 pages and dealing with all these things that we want to see. But looking forward to what's happening hereafter.
Indeed. Thank you, Theo. Keith, you had a point there. Jump in, please.
One of the things that you're having trouble with, Theo, is that, remember, transfer pricing in Section 31 is all about law, and you're now in court. Now, it's a very big step. That's why this thing is such a big step, is that transfer pricing is a facts and circumstances analysis, but that really doesn't work well in tax law generally. And so what they tried to do in the OECD guidelines are trying to take some of the subjectivity out of things. And so there's a presumption, that's why with a cup, that we're looking, if we can find an easy, quick answer, we'll jump to it because we've got lawyers and we've got people, not valuators, driving this process. So when you look at the guidelines, oh, wow, a cup is there, let's take it. Secondly, when we look at all these methods that we have, when you're making adjustments beyond the thing, so you do a cup and then you make adjustments, or you do a profit split, make adjustments, now you're into a very difficult area. Here's the first case, and once you start making adjustments, what is to say a good adjustment versus a bad adjustment? So I would think that your typical lawyers, the judge, and the people, the advocates who are driving the case, as well as a lot of people, would prefer to stay away from an open-ended adjustment process. And so that's why you've probably seen that, if we can avoid adjustments, we will, because it sort of says, well, there comes a point, well, I don't know, does the methods mean anything? I'm not saying that, and what I'm saying is it's a question of skills. You are an evaluator. You're comfortable with all these adjustments. Lawyers and the accountants in this process, this starts getting beyond them. And so making adjustments is just not a natural thing. Then just to make a second point that's going back a little bit where Rachel was, I see that there's a difference between trademark, brand, and goodwill. Maybe they're technical differences, but I am having a lot of trouble economically. That when I look at intangibles, I look at it in two sets of intangibles. One is hard intangibles like a license to software or something like that. And then there's the soft intangibles like brand, trademark, goodwill. Yes, I can see that goodwill can't be sold separately and trademark can. Fine. But when you're looking at an economic analysis, I'm having an awful lot of trouble when I look at it economically to distinguish the three. And I think that's going to be a big issue because we see this in other places. So if you're in Kenya or something, or in your other African countries, they're looking at it from an in-down perspective, and they're saying, let's say goodwill. Well, is it my goodwill because I'm selling it in the local market, or is it the international goodwill? And distinguishing those, I think, are very, very hard. And I must say that that's a lecture in and of itself. Anyway, I think I've just jumped in a lot because I know Theo's ready to go, so I want to step back. There you go.
Yep. Okay, quick one on that, Keith. Look, I think this is the point. It is so complex, and the starting point is if you haven't gone about and tried to identify intangibles, which have now become from a 7% of your business to potentially a 90% of your business, there's a lot of work to be done, because intangibles are sitting in there, hiding, driving revenues, driving profits, and currently not properly understood or documented. I think the next key point is that the problem with related parties and intellectual property is they don't do the analysis to get to the right process. And like what Theo and Rachel will do, when it's a third party and they want to sell their IP, trust me, they're going to value it. They're going to do the calculations. They're going to care about the adjustments, right? Because they're dealing with a third party. That's the arm's length process of determining it. And we have to start more robustly applying what we would do in a third party situation to our group, because that's basically what transfer pricing is. So we've got to be starting using the proper valuations, the proper analysis, because when this comes and is tested in the courts, that's what they're going to look to. They're going to look at your third party arrangements, whatever they may be, and where you properly applied the negotiation process and your due diligence. And the fact of the matter is it's currently not always happening when it's connected, but it will happen if it's not. So that's the bit of a change we need to see. But listen, we are on time. I think, Theo, you had your hand raised. I'm going to give a final word to everybody, and then I'll just thank everybody for joining us. So Theo, I'll start with you. Theo's had enough. Theo's had enough.
Theo's on mute.
He's on mute.
I apologize for that. Cabrini, I cannot agree enough. Keith, with regard to transfer pricing in the OECD guidelines, if you search for intangible assets through those guides, 660 pages of intangible assets, you will find that the bulk of the guidelines were written for other things than intangible assets. Yeah. And that the CUP, the CUP method, largely is a given, fixed, unnecessary to adjust methodology for those. If you go through it with a fine-tooth comb vis-a-vis intangible assets, you will find that it's less certain. And my comment, therefore, is vis-a-vis the OECD guidelines. I think if you interpret them correctly vis-a-vis IP or intangibles, you're going to find that it is not so in love with CUP as it appears and as it was made out to be in the court case. And then secondly, vis-a-vis goodwill, it's what Cabrini said as well. Whether you like it or not, clients will sell a trademark with goodwill out of a business, and the residual business will retain its residual goodwill. And whether you like it or not, business people will split those goodwills. And whether you like it or not, valuators and lawyers will have to follow. Thank you so much.
Thanks, Theo. Keith, Rachel, final words?
Yeah, I'm just saying it's interesting to how this case came in. Remember, this is an old case. I think the one thing, it's just a subtle difference again in the background, and I'm just mentioning it, is one of the issues in SARS is their audit function. Now, the real thing when it comes to transfer pricing that's a worry is paying money outbound. That's the big worry. If you are a South African company owned by a UK company, or a South African company owned by an American company or a German company, that's the real thing you need to defend. One of the things that points out in this case is that SARS has a problem on an audit function. That when they focus on large business center and all of this, they tend to focus more on local parents rather than foreign parents. And so some of this is, there's a general audit preference to going after our own multinationals than worrying about the foreign.
Going after your biggest taxpayers locally. Not the right place to target your biggest local taxpayers.
This has been mentioned by lawyers in the past and people in an audit. There's an audit skewing, and there are a number of them. And even though that doesn't affect the case, it does affect their choice. So I just thought I should throw that in. Okay.
Very good point, Keith. And I am going to leave Rachel with the final word.
I'm actually just going to say thanks for involving me. This has been very interesting discussion, and I agree with Keith's points earlier that I think the goodwill aspect probably requires a separate lecture on its own, because there's probably a lot there that needs to be unpacked, and the difference between that, brands, trademarks, etc., and where that sits. So maybe we'll have another one soon on that.
Absolutely. Rachel, Theo, and Keith, it's been a pleasure. Really appreciate having you here. And thanks. We had a great audience. Over 100 people signed up for this. So thanks for everybody for listening and joining us. We will share the slides out, and we hope to have many more engaging conversations around what we think is a super interesting topic, at least. So thank you, everyone, so much. Appreciate it.
Thank you.